commentary for use in practice. My name is Michelle Wong, and I'm your host for today's session. So before we begin, let me run through several housekeeping matters. So firstly, kindly ensure that your Zoom username reflects the name under which you registered. This will allow us to accurately mark your attendance and, where applicable, issue your certificate of participation and also for your CPD points. Secondly, if you have any questions during the session, please feel free to leave them in the chat box. Alternatively, you may also raise your questions during the Q&A session at the end, where you have the opportunity to voice them out directly. And now it is my pleasure to introduce our panelists for today. Firstly, we have Mr. Rodney Martin. He is the Chief Executive of Charlton Martin Group with over 38 years of global experience in construction, contract consultancy, dispute resolution, and dispute avoidance. Mr. Rodney Martin is also dual qualified in quantity surveying and law. He is a fellow of the Chartered Institute of Arbitrators and sits as mediator, arbitrator, and adjudicator on various panels, including the Asian International Arbitration Center, AIAC. We also have Mr. Daniel Tan. Mr. Daniel Tan is the principal of the law firm Tan Chun Hao, with dual qualifications in civil engineering and law. Mr. Daniel Tan has over 30 years of experience advising contractors and owners in the engineering and construction industry and regularly acts as advocate in arbitration and adjudication cases. He is also an arbitrator and adjudicator on several international panels, including AIAC, the Hong Kong International Arbitration Center, and the Shenzhen Court of International Arbitration. And we are honored to have such an experienced panel with us today. And without further ado, I will now hand over the session to Mr. Rodney Martin and Mr. Daniel Tan.
Thank you very much, Michelle. And if I just may start off, the way we're going to run this session this afternoon is we have some slides ready to go through the rules, the BICAM rules on expert determination. And I'll go through the slide, and then Daniel will add some comments on areas of practical concern that we think need to be addressed. So without further ado, if I may, Michelle, can we have the next slide? So what we're talking about this afternoon is expert determination. And before we go to the very necessary rules for expert determination, I just wanted to define the term so everybody is clear. Expert determination is a private and binding dispute resolution method where an independent expert is appointed to assess and resolve specific issues. Now, typically they may be of a technical nature, to do with a financial dispute or valuation matters. And both Daniel and I are very much involved in the construction industry and dispute resolution in that area. So technical issues and valuation matters for construction work are very much what we deal with, whether we're sitting as arbitrator or advising the parties to a dispute in construction. So expert determination is now another method of resolving disputes, and it's quite novel. As you'll see as we go through the rules, it's quite novel in getting in early, perhaps on a particular individual dispute or several disputes. Unlike arbitration or litigation, expert determination is more informal, and therefore, related to that, it's usually more cost-effective and efficient and avoids lengthy legal proceedings, as we may see in arbitration or to a lesser extent in litigation. Next slide, please. So with any dispute resolution methodology, we do need a set of rules for procedure, and BICAM has been quite instrumental in leading the way with coming up earlier this year, in April this year, with its own set of rules applicable to expert determination as a alternative dispute resolution methodology. So the first issue, and this deals with rule number 1, when do the rules apply? Well, the rules could apply to disputes that have arisen between parties to a contract in the following ways. Firstly, where parties have agreed that disputes between them be referred to BICAM for expert determination. Secondly, an agreement provides for expert determination under the rules through either an expert determination clause in a contract or a standalone expert determination contract. Or thirdly, BICAM is required to appoint an expert for expert determination, and then the rules would apply. As I said earlier, the rules came into force on the 15th of April this year. So over to Daniel, perhaps to deal with the first practical consideration we've come up with for the application of the rules.
Yeah, thanks, Rod. I think one of the first steps in the expert determination process would be to decide when you agree or try to incorporate a expert determination clause into a contract. Now, as Rod has mentioned, there are primarily two ways. One is you have it as a clause in the principal agreement between the two parties, so that during the course of the execution of the contract, if a dispute arises, then parties already have a mechanism in place for disputes to be addressed in a very short notice period type situation. The alternative way is you've got existing contracts that are being executed. There's no expert determination clause, and parties then later on decide, okay, we've got an issue that has arisen and we want to have this referred to an expert, and then you enter into a separate expert determination agreement. And I believe the BICAM rules have a template, pro forma template for such an agreement. So parties can look at that and use it, amend it as necessary, and then sign it and then implement it and get the process going. Now, I mean, I think all of us have had some experience in arbitration and adjudication. What we find is that if you don't incorporate a dispute resolution clause in the principal contract, you'll find that it's later on to enter into an agreement for expert determination, for example, it will be a little bit more difficult. It's always easier when parties are negotiating a contract. There are no disputes between the parties, and the relationship between parties is still quite cordial. It's a lot easier to then incorporate the ED clause or expert determination clause. So yeah, once the disputes arise, as you know, human nature is such that people take an adversarial position, and it's a lot more difficult to try to enter into a subsequent agreement for expert determination. On this note, it's probably good also for perhaps BICAM to take some initiative to try and have a proper expert determination clause incorporated into some of the standard form contracts, and they'll have to maybe lobby the respective institutions who do promote these forms, and see how they get on with that. That way, the mechanism for expert determination will be readily available to the parties. Now, in terms of standard forms in the construction industry in Malaysia, at the moment, PAM does have references in their standard forms to expert determination, but they are not mandatory. They're just there for information of the parties, and if parties should choose to go to expert determination, then they can invoke it. But it's not a mandatory process. But I think for expert determination to be effective, you really have to sometimes take the bull by the horn and make it mandatory, and parties will then be able to hopefully resolve their disputes in an expeditious manner. I think that's all I've got to say, Rob. Unless you've got anything to add, I'll hand the floor back to you.
Thank you very much, Daniel. I totally agree with what you're saying. It's much better to get the clause negotiated and agreed up front when the contract is signed. Doing it afterwards, as you say, when there's a dispute, a large dispute, the parties won't agree on anything. The other point I wanted to make is that care needs to be taken. And I know this evening we've got many lawyers listening to us. Care needs to be taken when drafting the whole dispute resolution clause to make sure that it is complete and appropriate and that it works. Sometimes standard forms are taken and amended poorly. Sometimes not enough attention is placed on the appointment of the expert or the tribunal, etc. So it will be very important. Now, whether that can be mandated as compulsory, that's a tricky one, because I see expert determination perhaps as suitable for some types of disputes, but not necessarily all. If we take the average large construction contract, there'll probably be an extension of time dispute, variation claims, loss and expense claims, disruption claims. I think, for example, expert determination is perfect for resolving variation claims because of their nature. And to have for example, QS to come in as an expert and be the expert in the expert determination process would save a lot of time and a lot of money. And I think we know on arbitrations, very often the variation claims, or the straightforward ones, are often negotiated during the process of arbitration to keep away from unnecessary cost. So there we may have an example where expert determination would work very well. And yes, I agree, mandating it for those sort of claims would be a good practice for the parties to agree up front. Okay, thank you very much. Next slide, please. Next question. So we've got a clause, we've got a procedure. How is the expert actually appointed? Well, the BICAM rules 4, 5, and 6 deal with this. The experts may be appointed by the parties or by BICAM itself. The fees and expenses payable to the expert in either case shall be agreed between the parties and the expert and formalized in a fee agreement. Now, as the expert becomes more experienced at expert determinations, he or she will have probably their own terms and conditions which they wish to propose. Otherwise, it'll be really up to the parties to jointly come up with terms and conditions which should be entered into with the expert. By appointing the expert, the parties agree that the expert determination process is not an arbitration and is not an adjudication with the meaning of those terms in any statute or at common law. An important distinction to make. Daniel, the next practical consideration we've got is identifying a suitable expert. I think that's the core, that's the heart of the success of expert determination, getting the right expert on board. What do you have to say?
Yeah, I think parties have, well, they won't know this when they sign the principal contract at the beginning. Nobody knows what sort of disputes are going to arise. But when the dispute does arise between the two parties, they need to identify exactly what is the issue, make sure that both parties are of the same mind as to what the issue is in dispute, and then think of a suitable candidate or candidates that can review the issue and give a proper determination on the dispute. Now, how do you choose an expert for the determination? Well, it may be an area where a particular qualification is required. I mean, Rod, I think you mentioned just now variations and quantity surveyors. So if your dispute is in relation to a variation, then a quantity surveyor may be the best person to assess that particular dispute. Take a look at the circumstances, take a look at the dispute, and then see what sort of qualifications you require of the expert. Look at experience that particular expert has, and see whether the experience matches with the area of expertise required from that particular expert. Sometimes you may find a situation where one sole expert may not be sufficient. A variation claim, for example, we were talking about earlier. You may have to look at areas in terms of liability and areas of quantum, and areas of liability and quantum may require different experts. So the question will arise then is whether you need to appoint two experts, and I think the BICAM rules caters for that. So it doesn't restrict you to just appointing one expert. You can consider two or more experts to be involved in the process. One of the benefits of I can see from expert determination is that you select the right expert to make the decision. Then the process should not require, in a traditional sense, expert witnesses that we usually call for arbitrations or litigation cases. So it's well, hopefully will avoid the necessity for calling expert witnesses later on, which will add more time and cost to the whole process. Another area also, when considering the appointment of an expert, I think for lay parties is a conflict of interest. Now, I think lawyers who are present here today are already familiar with the whole process of conflict of interest. Last year, the IBA Guidelines 2024 edition was released. If you all don't already have a copy of that, just log on to the IBA, International Bar Association website, and just download a PDF copy of the guidelines, go through it. It's an expansion, I think, of the previous version. I think it was a 2014 edition. Go through it, get a feel for when conflicts do arise. And this is particularly relevant for those of you who want to sit as an expert, to understand and appreciate difficulties that can arise if a conflict arises, and to what degree a conflict needs to be disclosed, or to what degree a conflict will basically exclude you from consideration to be an expert. The other thing also is that the expert determination process is done on very, very short notice. The process is, I would say, very fast-tracked, in the sense that hopefully there's only parties are able to focus on one or two issues, and the expert can hear submissions from the parties and render a decision in a very, very short period of time. As we all know, the good experts, the good arbitrators, the good lawyers, good consultants, when you want to engage them for any services, there's usually a bit of a time lag because they're so busy. So that's a factor that you need to take into consideration, how much time you have in your hands to first of all find the appropriate expert, to find an expert who is able to drop all his other work and take on the brief. And I think that's all I really have to say about the selection process, you could say. Over to you, Rod.
Yeah, I think you've covered it very well. Just a couple of extra points, practical points. You really have to be very, very careful about the choice of expert. We can't emphasize that enough. Of course, BICAM has its own procedure for empaneling experts, and it does its own checking. But of course, it's very important because each dispute will be different, be unique, and it's very important to get the right person. There are some experts, so-called experts out there, who will profess to have expertise. You really need to take third-party references and check out the market. In Malaysia, it's a relatively small scene, although there's plenty of projects and plenty of disputes. The number of lawyers, the number of experts in the market who are active are relatively few. If we take construction lawyers, it's a small pool, and it shouldn't be too difficult to get a number of references about an individual to make sure that they can actually do, and they do have the expertise to which they profess. In terms of the conflicts of interest, is a very important area. I've been personally doing expert work for about 20 years now, and the market has grown considerably, and a lot more attention is placed on conflict issues now. As Daniel mentioned, the IBA rules were very important when they came out in 2014. They've now been updated again in 24. Those matters really have to be taken into account carefully, not just at point of appointment, but thereafter, checking, making sure there are no issues which arise which could result in a potential conflict. And of course, the appointed expert must disclose any issue as it arises, should it arise, to the parties as the matter proceeds. The good point, of course, as Daniel has touched on, is the procedure for expert determination is relatively shorter than an arbitration would be. So the zone of potential issues with conflict will be a shorter and less of a risk from that respect. But I think, yes, that's all I would add to what Daniel has very well covered on the appointment process. Next slide, please. So just a little bit about how the expert is appointed. Where the parties have agreed on the appointment of an expert and the expert has accepted the appointment, the expert shall be deemed to be appointed by the parties on one proviso, and that is that the expert notifies BICAM in writing of his or her acceptance within 7 days of the said acceptance. And that's a procedural requirement, so that BICAM is aware that the expert has taken on the appointment and the expert determination process is live. Where parties have not or are unable to agree on the appointment of an expert under the Rule 5, a party may request BICAM to make an appointment. Appointments by BICAM shall be undertaken within 14 days, a relatively quick, short time period, which is good, of the receipt of certain information, and shall be final and not subject to an appeal. So the next practical consideration we want to look at is the appointment of the expert in terms of appointment, remuneration, and so on. Daniel, over to you.
Yeah, thanks. The BICAM rules do not actually set out the terms of appointment of an expert, and the reason for that is that it's too varied, I think, an area to be able to come up with a standard form terms of appointment. As we mentioned earlier, you need to identify what is in dispute, select the appropriate expert, and then sit down with the expert to negotiate the terms of the appointment. What does the expert require for his appointment? And then bespoke or customize something, some sort of agreement, terms of agreement on the appointment of the expert. The rules do, however, do provide general description of the obligations of the expert, and these can be incorporated into the terms of appointment to be independent, applied to act within his jurisdiction, and so forth. But the actual terms need to be discussed, agreed, and it's going to be a tripartite agreement. It means both parties have to agree to the terms as well as the expert. And I'd suggest, some people may think, can we get away with an oral agreement with the expert? I'd suggest not. Best to confirm everything in writing, so if there's anything that needs clarification later on, there won't be any misunderstanding as to what was actually agreed between the parties and the expert. And this particular terms of appointment should set out the precise role of the expert, so that there's no confusion as to what's expected of the expert later on. Set out exactly what the expert's required to give a decision on. The other thing that the rules don't really go into much detail is the remuneration of the expert. It's been kept open-ended because, again, depending on the nature of the dispute, the type of work involved in preparing for the case, the amount of research that the expert may have to do, the remuneration is going to vary. So again, the parties need to sit down with the expert and agree some sort of a fee structure with the expert, whether it's a lump sum time cost or a hybrid between time cost and lump sum. I think that's all I have to say. Over to you, Rod.
Thank you, Daniel. Yeah, I think the precise role is very important because there could be issues with excessive jurisdiction later on if there's a misinterpretation by the expert of what's required of him or her. And of course, the other terms, very, very important. As I mentioned earlier, if the expert has previous appointments, the expert may be able to provide a draft proposed terms and conditions which would be acceptable to that expert as a draft for the parties to work on. If not, they'll need to get together and agree. And as we said earlier on, that's not always easy if the parties are in dispute and they're not totally on board with the idea of expert determination. The idea, if there isn't an obligation in the contract to go to expert determination from the outset, the idea and force behind going to expert determination may come from one or other party. It's unlikely to be an even request and consent there. So these things are sometimes troublesome, but of course, if the parties can see the benefit of expert determination, then hopefully they can overcome those problems. On to the next slide, please. Rule 7 deals with the obligations of the expert, and they are as follows: to possess relevant qualifications and experience and a field of expertise covering the subject matter of the dispute, acting as an expert and determining the dispute expeditiously, cost-effectively, fairly, and in accordance with the BICAM rules, adopting and implementing a procedure that is suitable, expeditious, cost-effective, and fair for the expert determination process, independence and impartiality, and complying with the principles of natural justice, disclosure of any circumstances at any time which may undermine the expert's independence and/or impartiality. So those are quite comprehensive. They give the expert quite wide range and powers of how to proceed. But I think the core principles of getting on with the job, being cost effective, fair, and obviously independent and impartial, and observing natural justice are the core to any dispute resolution process. Daniel, anything to add there? Any comments you'd like to make on that slide?
No, I think it's fine, Rod.
It's pretty straightforward and sets out very well what the obligations are, and I think most people will understand where the rule is coming from. Okay, next slide, please. So leading on from obligations, obviously powers of the expert, and this is dealt with in rule number 8. The expert is not bound by any rule of evidence and has various powers to exercise at the expert's sole discretion and as deems necessary and appropriate, such as the following: determining the dispute in accordance with the rules, establishing the procedures in the conduct of the expert determination proceedings, including calling hearings, setting deadlines to produce documents and/or witness statements, relying on and use the expert's own knowledge and expertise, inspecting the site, property, work, product, material, or goods in relation to the dispute, awarding financing costs and/or interest, and extending any time limits imposed by the parties by the BICAM rules. So that's more practical procedural powers to implement what Rule 7 is in terms of the obligations of the expert. Daniel, what do you have to say about this?
Yeah, I think the procedure to be adopted for any expert determination needs to be set out right at the beginning of the expert determination process. So once the appointment of the expert has been sorted out, the expert should call for a meeting, or at least through correspondence, discuss with the parties what is the procedure that they're going to adopt for this particular process. And I think the expert should be the person that takes the lead on this with the guidance of the parties, because the expert is the person who will be dictating exactly what information, what documents that or evidence that the expert requires in order for the expert to make his or her determination. So yeah, I think there should be some sort of a meeting or through correspondence process which ascertains exactly what the expert requires to progress the dispute. And in a situation like that, I think the lay expert has to be mindful that there's no restriction on the representation by the parties, so lawyers can be present. But I think from the user's perspective, perhaps the users need to consider very, very carefully whether the involvement of lawyers is actually necessary. Sometimes on very, very technical issues, very, very factual issues, it may not be necessary for lawyers to be present. Because I find that quite often lawyers take a very adversarial approach. I think that's their training, that's the way they think, and that's the way they normally react. But in a situation well, expert determination may not function as well if you're placed in a situation like that with very adversarial lawyers that are present. So if you get lawyers who are quite amenable to assisting the process itself, then that could be quite useful. Now, for the lay expert as well, I think the legal experts or people who have been involved in arbitrations or litigation before, procedure is something that comes quite naturally because of their experience. For the lay expert, maybe procedure is going to be a problematic area because they haven't done this sort of thing before, or they haven't done much of it before. So they need some guidance on the process required to, that's, for example, take evidence, consider the evidence, and how to go on to make the decision after that. At the outset of the process also, I think it's important for the expert to decide whether or not a oral examination of witnesses is required at all, or oral submission by the parties is required. Because of the short process, the short duration for the whole process, these are areas that I think experts should try to avoid convening unless it's absolutely necessary. Because to fit in oral hearings, I think is going to be quite a challenge. It can be a challenge, and you'll be surprised. A lot of experts or lay arbitrators or experts actually have no idea how to conduct a hearing as well. So yeah, they need to be very careful. If they're going to call for oral hearing, they must have some knowledge as to how to do it. So, Rod?
Thank you, Daniel. I agree. Everything you've said is very important for the potential parties involved in expert determination. It has its great benefits, but also potential drawbacks because it is lacking in procedure in some ways, in the way that arbitration and obviously litigation has a very well developed procedure. And I think the most important thing you said there is the expert must take the lead in the process. The expert has been bestowed with the authority, the power, and the great responsibility to decide this dispute. And it's up to the expert to make sure that happens in the most expedient, fair manner possible. Going down the route of having hearings is not unnecessary, but it could be problematic, especially, as you say, for those lay experts without formal training in other alternative dispute resolution processes. And it could undermine an otherwise useful determination if challenged. It wouldn't be appropriate to say, as an expert, I don't want to see any lawyers, because that might not be fair and necessary. But I think setting out exactly what's to be provided, mainly written submissions would be what we would expect in expert determination, and explaining why the process needs to be the way it is would possibly solve a lot of problems. But it's an area that the expert has to take care of and be careful and ensure the process is followed through. Next slide, please. Okay. Now, what happens if the expert, for whatever reason, needs to be replaced? Rule 9 deals with this. The expert may be replaced by the parties in the following circumstances: by mutual agreement between the parties, due to illness or other incapacity of the expert, a conflict of interest arises after appointment requiring the expert to resign, the expert is unwilling to reach a determination within the agreed time, or the expert has, as a matter of fact, not reached a determination in the required time as set out in the rules. In such event, the expert determination process will be suspended until a substitute expert is appointed. So these rules, these facets of the Rule 9 seem to me very similar to the circumstances where an arbitrator needs to be replaced. I think it's fairly straightforward, and with the majority of lawyers listening in, I think there should be no issues with that. Daniel, anything to add?
No, nothing to add. Thanks.
Yeah, thank you. So next slide, please. Moving on. So now we get into the actual procedure set out in the rules of how the expert determination is to be conducted, and those can be found in rules 10 to 14. We've got 2 slides on this. We'll deal with the content of this slide and then we'll discuss it and then do the same for the next one. So the parties are required to be represented by an individual with authority to agree on procedural matters. That's the key. The representative must have authority in order to move the matter forward. No point the representative having to go back and seek approval on any issue from another person. The authority must be there. That person representing the party has to assist and cooperate with the expert so the expert can determine the matter, and that might include, for example, giving evidence. Comply with all the expert's directions and rulings regarding the procedure and evidence. The parties agree to continue to perform their contractual obligations under the contract, notwithstanding referral of a dispute to the expert. Well, that's similar to what happens sometimes in arbitration proceedings, where under the contract arbitration is allowed to proceed before the work is complete, for example, in the construction contract. Sometimes a clause says, well, you can't go to arbitration until completion because it might disrupt the performance and the relationship of the parties. Many government contracts used to have that provision. Well, here, the rules make it clear that you must perform your contract even though you've referred a dispute to expert determination during the course of the contract. Next, the parties are to adhere to the timetable set out under rules, 7 weeks from appointment of expert for the filing of submissions, for example. And the expert is required to complete the briefly reasoned determination, signed in writing within 3 months from the last submission from a party. So again, there's a timescale set out in the rules all the way through from the appointment of the expert to the rendering of the determination. And the determination is only released when all fees have been paid by the parties, which protects the expert being paid. Daniel.
Yeah. Only a couple of minor comments here. I think we've already touched on the area on the submissions prepared by the parties to be made to the expert. I just want to emphasize that the parties, particularly in an expert determination, need to meet the requirements of the expert, find out exactly what the expert requires, and make sure that the submissions tally with the requirements of the expert, so nothing's left out. Otherwise, you're going to be compromising your own position. We've dealt about the necessity for oral hearings or clarifications. Make sure that the submissions address the necessary facts and factual arguments, if there are any. You need to consider whether opinion evidence is required, notwithstanding the fact that, okay, you've got an expert who's going to make a decision, but does that expert cover all the necessary areas required to properly resolve the dispute? If there's a need to call third-party expert witnesses to adduce statements or affidavits, then so be it. These are things that need to be considered. And certainly, most disputes involve legal arguments as well. You need to support your legal arguments with relevant authorities and so forth. And if you are a lay party representing yourself in the expert determination process, well, this is an area where you may need to consider engaging lawyers to assist in the preparation of the submissions. I think that's all I have, Rod, on this.
Okay, thank you, Daniel. I have nothing else to add on that one. Next slide, please. So again, looking in a bit more detail about the timeline and the obligations of the expert under the procedural rules. As I mentioned just now, the expert's required to complete the determination within 3 months from the last submission from the parties. Now, that's not a terribly long time, neither is it a terribly short time, I would say. Of course, it all depends on the complexity of the matter that's being referred. It may be necessary in the negotiations of the appointment for the expert to negotiate more time if that's what he considers or she considers necessary. The determination shall include brief reasoning unless dispensed with by the parties. The determination is to be in writing and signed. The expert is not required to release the determination until all fees have been paid by the parties. And then only correction for clerical or computational errors may be made to the determination at any time after completion of the determination. Now that's a bit similar to the situation under C for adjudications, similar provision. And the determination should be final and binding on the parties, which is perhaps maybe considered one of the more controversial provisions of the rules. And I'll just ask Daniel if he's got any comments on that.
Yeah, I think when it comes to writing the determination or the decision, experts need to be very careful, especially if they're lay experts, people who have got no legal knowledge or legal qualification. It's no walk in the park. The experts will have to have some knowledge on jurisdiction. They have to have some understanding as to what natural justice is. We talked about procedure earlier, how they need some knowledge about procedure and how to implement the procedure agreed to with the parties. And the expert needs to know how to receive evidence. How do you receive and weigh the evidence that's produced by the parties? And if there are legal arguments submitted by the parties, how do you process the arguments on law and make a decision on law if the need arises? The expert also needs to have some knowledge on what is the burden of proof, what is balance of probabilities, because these are all things that will affect the way the decision is made, and in ensuring that the decision is going to be properly enforced later on. And certainly for technical disputes where the expert is required to exercise some professional duty of care in giving advice or making the decision, they too need to understand that there are potentially liabilities attached to not giving the right decision advice to the parties. Rod?
Thank you, Daniel. I think that takes us right back to the beginning of the process. When a would-be expert is approached, the expert needs to consider and find out as much as possible about the nature of the dispute, and therefore whether the expert has the capacity, the experience in order to render the decision and the determination at the end of the day. So all of these need to be taken into account. And that's also true for the lawyers who may be asked by their clients to recommend candidates for experts. Have to take all that into account. What are they going to be doing? What's their end product at the end of the day? It is a properly produced determination with all the necessary ingredients that Daniel's just covered. Okay, I think we'll go to the next slide, please. So can the expert determination be challenged? Rule 15. A party may challenge the determination in the courts only if the making of the determination was induced or affected by fraud, collusion, partiality, bias, bribery, and/or excess of jurisdiction. Unless otherwise permitted by the applicable law, a challenge shall be made to the court not later than 14 days after the receipt of the determination. So a relatively short period in which to make a challenge, and very clearly limited grounds for challenging the determination in the first place. Daniel?
Yeah, I think the period to challenge a determination is actually extremely short. And again, like trying to select an appropriate expert who can take the matter up on short notice, you need to get the lawyers on standby to do this whole process as well. And again, getting good lawyers to be on standby to file an application in court to challenge a expert determination is not going to be a walk in the park again. And I think the grounds for challenge in the rules are relatively narrow. But you know, you get a good lawyer on board. Sometimes they're pretty imaginative. They can construe or try to construe any so-called irregularity in a determination and make it an excess of jurisdiction argument or a breach of natural justice argument. But what we have seen in Malaysia, in the case of integrated training and services against the government of Malaysia, is that the courts have actually upheld the sanctity of the agreement between the parties to go to expert determination, and they're actually reluctant to overturn or declare expert determinations invalid. In this particular case, the matter went up to the federal court, and it involved an independent auditor appointed by the parties to assess sums and expenses properly and necessarily incurred by a contractor in a project. And the federal court held that once parties have agreed to the mutually appointed expert parties are bound by the expert's determination, the court will not generally intervene in a matter which is within the jurisdiction of the expert, save in the narrow circumstances where vitiating factors such as fraud, collusion, or partiality bias can be shown. In this particular case, there were irrelevant documents that were considered by the expert, but the court held that it does not undermine the expert's decision. So if we look at the decisions from overseas, the main principle for challenging a determination is a manifest error in the determination. And what the courts have said is that there must be an obvious error that is easily and swiftly determinable. And even if the reasoning is wrong, it is not sufficient to invalidate an expert's decision. So you can see that they set quite a high bar, and that a manifest error must also have an impact on the expert's decision. So the general consensus overseas appears to be upholding the expert's determination without interfering with it. Now, then you ask yourself, in the rare occasion where a determination can be challenged and is successfully challenged in court, what happens? Well, a couple of things that have happened in courts overseas is that the court may remit the matter back to the expert for a correction, okay? And the court may require a new expert to be appointed to determine the matter. So the matter is decided by another expert, not the same expert as before. Or the court may actually direct an alternative machinery to be used to determine the matter. So even the court could make a decision and close the whole chapter if necessary, if the court considers appropriate. So those are possible outcomes. But we haven't seen, well, I haven't seen any cases in Malaysia on what happens after a successful challenge of a determination in court. Rod?
Thank you, Daniel. It all goes back, I guess, to making sure as far as possible that you get the right expert and that challenges are just not necessary, because as you say, the bar's very high, and most of the time the parties will be left with the determination that's been rendered. Okay, next slide, please. Now we are coming to the end of the session. We will be finishing at 6:30 and we will get through our slides, but if anybody's got any questions, we'll be very happy to deal with those when we finish the slides. Next slide, how are costs dealt with under the rules? Fairly straightforward. The parties shall bear their own costs in respect to the expert determination process. All other costs, including the cost of the expert, room rental, transcript services, and the like, if any, we hope there won't be any of those, shall be borne equally by the parties. The expert may issue directions on the payment of security deposits by the parties to cover the costs of the expert and/or BICAM. The expert may suspend the expert determination process if the parties fail to comply with the expert's directions on payment, and terminate the same if the default continues for more than 14 days of the notification of the same in writing. Well, fairly straightforward. The expert doing his job expects to be paid, and it's quite reasonable for deposits to be requested so that the expert determination, when ready, is not held up unnecessarily because one or other of the parties haven't paid their dues. I don't think you've got much to say about that, Daniel, have you?
No, nothing to add there, Rod. Thanks.
Okay, we all like to get paid on time for what we do, don't we? Right, number 30, next slide. Okay, so now in the rules, and please download or take a copy from BICAM, rules 17, 18, 19, 20, and 21 deal with general matters such as confidentiality, waiver of right to object to an irregularity in a timely manner, subsequent proceedings, the expert not to be called, immunity of the expert and BICAM for acts or omissions done in good faith, and service of notices and documents where usual physical service methods plus email are prescribed. So the usual type of procedure and protocol on maintaining confidentiality, as we would see in arbitration or adjudication proceedings, etc. So nothing particularly unusual there. Please have a look at the rules. Daniel, anything you wanted to add?
Yeah, I think in respect of immunity of expert, I think it's an area that we need to be very careful because this immunity is not a statutory immunity. I know it's in the BICAM rules, but I think experts who are acting as experts in this sort of a procedure need to be also very mindful that they don't take it for granted that there's no liability like that they'll be can be attributed to them. Yeah, I think you just need to be very careful. I think that's the only remark I'd just say then.
Yeah, good point. You're not necessarily immune, and everything you do might not be seen as being in good faith in any event.
Yeah.
Thank you. Next slide, please. So lastly, really, before we come to the schedules at the back of the rules, what are the functions of BICAM as the appointing authority under the rules? So it's an administrative role. At the request of a party or the parties, BICAM will appoint an expert and provide administrative support for the conduct of the expert determination under the rules. BICAM has a panel of experts comprising of individuals with appropriate qualifications and experience in their respective fields of expertise, and upon a request, BICAM will select a suitable individual from the panel of experts. The nominal fee of 300 ringgit is for appointing the expert, and admin support, again, a very low amount of 1% of the expert's fees plus any applicable taxes. The parties and the expert agree on fees and expenses and enter into a fee agreement within 14 days of the expert's appointment. Very important because that would obviously cover BICAM's right to be paid for their part in the process. Daniel, any comments?
No comments there, except I think I know there are a lot of lawyers present here today, but the expert determination process, I think you will find in the long run, will not actually involve lawyers that much because expert determination, I think, generally caters for a lot of technical disputes where the involvement of lawyers may not be so evident. And what you'll find is that experts who are appointed tend to be people from the industry. It could be from construction industry, engineers, QSs. They could be accountants who are doing valuation and attending to valuation disputes. A whole bunch of other industry areas. So if you look at the categories for empanelment, which I believe you can find in the
probably Schedule B,
rules.
Daniel, the procedure,
Yeah.
probably there. Yeah.
Yeah. So there's the categories of experts extends to property and real estate, financial, commercial, insurance, medical. I mean, legal is included, but IT,
Yeah.
cybersecurity, etc. So it caters for a wide scope of categories from various aspects of the various industries that we all work around in. And yeah, I think that's all I have to say about the categories.
Yeah, I mean, as I was going to say, you're quite right, Daniel. The emphasis is on technical, commercial, financial disputes, but as you mentioned, there is a category there for expertise in the law, and it's a possibility. So if any lawyers listening want to become impaneled, they can obviously do so. So I think the last slide before we conclude our talk is just to show you, if I can have the next slide. There are 3 schedules attached to the rules. Standard BICAM clause on expert determination, which Daniel mentioned at the beginning. Secondly, the procedure for empanelment as an expert. And thirdly, a sample form of contract for expert determination. All good reference documentation, which applies to the rules. Daniel, any further comments on what we said this evening?
I think not, Rod. The only maybe parting remark is that, the Schedule B, procedure for empaneled expert, if you have any aspiring experts out there, have a look at the procedure, get yourself empaneled with BICAM, and let's try and help this process work, because I think it's a great process for resolving disputes in an efficient and fast manner, I think.
I echo those comments, Daniel. I've seen expert determination be brought in to a fairly complex construction dispute. The subject matter was variation claims, and the parties agreed to an individual, and it was very successful in resolving the dispute and avoiding unnecessary costs. And I think that's probably the angle where expert determination can win over other methodologies. That's all I have to say. Michelle, if we've got any questions, or Marie, we'll be very happy to try and answer them.
Oh, actually, before I jump into one anonymous question that I've received, personally, I have one question for Mr. Rodney Martin and Mr. Daniel. So I understand that the decision from expert determination is final and binding, but in practice, have you ever encountered any situation where one party simply refuses to comply with the decision? And if so, what options are available for the other party in such a situation? Is it similar to arbitration where you enforce that arbitral award in court?
Daniel?
I think yes and no. There is no statutory framework for the enforcement of expert determination decisions. So it will be enforcement purely by contract. So if a party refuses to comply with an expert's decision, then that would be a breach of contract on the non-complying party. So the party wants to enforce the decision to go to court to enforce, first of all, allege breach of contract and claim for the breach, claim for damages arising from that breach. I think that's how it would work. Yeah.
So on that, Daniel, would you agree it would be useful to include some detailed provisions in the contract, in the expert determination agreement between the parties and the expert for that situation, if that happened?
Yeah, I think it'd be useful.
Yeah.
List out the sort of remedies that are available to the non-defaulting party, so that the courts can have a look at it and implement that. Because expert determination tends to be very, very technical in nature, not legal. It tends to be very technical, and sometimes the remedies required will be technical remedies, in which case these should be set out in the terms of appointment of the expert.
And to answer the second or the first part of your question, Michelle, no, I haven't found a situation or encountered a situation, but then I must admit there haven't been too many expert determinations I've come across. But I haven't found any. I didn't want to say that, Rod,
but neither have I.
But I have seen a few.
It's very new. Yeah.
Okay, thank you very much for the answers. As to the second question that we just received, this question reads, since experts are usually appointed for their technical or subject matter expertise, what happens if during the process, the dispute reveals legal issues or any issues outside of the expert's field of knowledge? So is it a situation that a lawyer be called in to be an expert witness, and how do they go about it?
Well, if I can just give some thoughts and then let Daniel correct me or otherwise, I think the expert would have to reach out, would have to inform the parties of the situation, and then the logical thing to do would be to agree to appoint a lawyer for the expert to seek the advice required. That would be one remedy. The other remedy would unfortunately be the expert may have to find that he'd have to resign, and there may be consequences to that. Daniel?
Yeah, I think that's certainly the likely outcome. Parties could also consider as to whether they want to bring in a legally qualified expert to help out, where you got two experts that will render decisions on different aspects of the dispute that have arisen between the parties. Or parties may just say abandon the expert determination and go to arbitration or litigation and get a proper legal ruling or decision on the dispute, that legal dispute that has arisen.
I think as a last word, I'd say, what's the best thing to do? What's the expedient thing to do? The parties have agreed to go to expert determination. They've hit a bump in the road. So how to resolve it? Can it be resolved under the circumstances? Do they want to agree, as Daniel says, to get somebody in to keep the matter alive, to still render the benefits of expert determination ultimately?
I think you also have to look at the issue of jurisdiction as well. And when parties first appointed the expert, what was his jurisdiction? If this legal arguments go outside his jurisdiction, then parties will may have to take it separately, take up the matter separately somewhere else, but still continue with the technical dispute with this expert.
Yep. Okay, thank you very much. Oh, Mr. Daniel, do you have anything else to add?
No, that's all. That's all from me.
Okay, thank you very much, Mr. Rodney Martin and Mr. Daniel Tan. I believe there are no further questions from the floor. So, and it's actually 6:30 already, or 6:32. So, thank you very much for our speakers, Mr. Rodney Martin and Mr. Daniel Tan, for their insightful commentary, and to all of you for joining us at BicTok 30-second session. And as a reminder, our BicTok sessions are held bi-weekly, so do keep an eye out on our social media pages for updates on upcoming topics and more engaging legal discussions. And we look forward to seeing you at our future sessions. And thank you once again. Have a pleasant evening, everyone. Thank you.
Thank you, Michelle, and thank you for everyone at BICAM for having us.
Thank you very much. Thank you.
Thank you.